Hello, friends. Welcome to Investment Immigration Conversations. I'm your host, Carolyn Lee, principal and founder of Carolyn Lee, Pllc, a U.S. investment immigration law firm dedicated to helping clients build their futures with investment immigration, our absolute favorite. So it's March Madness. It's the end of March, and we have a lot to share. There's a lot happening, and we're going to hit on a couple of the headline items today. So let's kick it off with something that I've been talking about. It almost feels like nonstop for the last few weeks, and I'm just returning to the States after a whirlwind 2-week tour of China, where we hit 6 cities, starting with Beijing, Shanghai, Shenzhen, Xi'an for the first time, the beautiful historic city of Xi'an, then Guangzhou, and then again, first time to the beautiful coastal city of Xiamen. There is a lot of excitement and interest as ever in the world's largest market for EB-5, China, second to India. And I was very pleased to be there and sharing what we think is reliable, high quality information about EB-5. And while we were there, we were able to dispel some unfounded rumors about the filing fees for EB-5 petitions going up by 4.2 million to get to the 5 million level. Untrue. And also talk about the retrogression in the unreserved categories reported in the April Visa Bulletin, which is the second topic we'll hit on today. So let's get to it. The gold card. So, of course, we're talking about the announcement made in late February, just about a month ago, by President Trump and Secretary of Commerce Lutnick about this new gold card program envisioned as a sale of a gold card at the $5 million level, the purpose of which would be to reduce our debt and in turn bring in wealthy individuals who would like the benefits of freely being able to live and stay in the United States with certain other benefits, including exemption from worldwide taxation, although they would be paying US taxes. So, and just very recently, just 3 days ago or so, the Secretary spoke about it again. And he announced that he had sold or pre-sold 1,000 of these gold cards already, and asked us at the end of that interview to watch for the card to be launched 2 weeks hence, which would take us to April 6th. So we'll be watching again at that time to see if there's anything concrete on the horizon. As of today, there is nothing concrete in terms of an actual benefit or a transaction that, to our knowledge, is available. There could be something that is not yet available on the open market for this type of visa or a card or benefit, but as of this moment, there is nothing that is available to be discerned by looking at public search sites. But it sounds like there is something cooking, so stay tuned. Visa retrogression in the EB-5. So of course, in all of US immigration, we watch for the monthly publication by the State Department of the Visa Bulletin. And a couple of weeks ago, the April Visa Bulletin was released, and it reported a 2.5-year retrogression, backsliding of visa availability in the EB-5 Unreserved category. So just as a backdrop and refresher, the RIA EB-5 Reform and Integrity Act of 2022 essentially created 4 sub-visa categories within the EB-5 category. And those 4 categories are the 3 set-asides that we talk about a lot, which are the rural, high unemployment area, and infrastructure set-aside categories that take up 32% or are reserved for projects in those classifications. And then there is the unreserved category for the pre-RIA investors and projects and post-RIA projects and investments that are not in those set-aside categories. So it's unreserved. And the allocation of the total annual limit of EB-5 visas, which in a normal year would be about 9,940, or we round up, we talk about 10,000 visas annually in the EB-5 space. The unreserved get 68%, or roughly 6,800, and the reserved categories, the set-aside categories, get the remaining 32, split up 20% in the rural, 10% in high unemployment, and 2% in infrastructure. So that's in a normal year. This year, because of the carryover mechanism in the RIA, we have a lot more numbers than the normal limit. We have about 11,500 in the unreserved categories, in the unreserved category. Now, we have had a backlog or cutoff dates published in the unreserved for mainland China-born and India-born investors. And they had stayed pretty statically in the 2016 and 2022 range, respectively, for China mainland-born and India-born investors for some time, until April Visa Bulletin was released, reporting a retrogression of over 2.5 years in both. So to read out the cutoff dates, in the March Visa Bulletin, the cutoff dates in Chart A for China was July 15, 2016, and January 1, 2022 for India, China and India respectively. In April, the priority dates retrogressed or moved up earlier in time to 22nd January 2014 for China mainland-born, and November 1, 2019 for India-born investors. So, and being right there in the eye of the storm, as it were, was actually the day in Shanghai that we had reserved to kind of work and take a little break and so on, that this news hit. So I think I gave 4 or 5 telecasts, interviews, mini webinars on this topic that day. So let's try to understand what's happening here. And that really was the key question. Why is this happening? And was this expected? What's going on here? And so we can start, when trying to understand this and unpack this, we can start with the State Department's own explanation, which is right there in the Visa Bulletin in the notes. And it says that due to increased demand and numbers usage by Chinese, Indian, and rest of world investors in the unreserved categories, that there had to be this retrogression. And moreover, that there might need to be the need to publish a cutoff date for the rest of world in the unreserved category at some point. So the explanation is that there was an increase, presumably unexpected increase, maybe a surge in the demand and usage of numbers by all the investors, essentially, in the unreserved category. So this would mean approvals. USCIS is approving cases in the unreserved category, so predominantly pre-RIA investors whose cases remained pending with USCIS. So the demand is there because the service is approving these cases. And usage. So these numbers are actually beyond presenting demand, they're actually being taken down, they're being used. So after approval, these cases are progressing to being documentarily qualified. The National Visa Center files are being completed, the applications are being completed, and the applicants and family members are appearing for interviews and actually getting visas issued in the unreserved category, beyond what was budgeted or expected by the State Department. I don't think that's surprising. And then not surprising in retrospect. And then let's look at the second sentence, which talks about the need to possibly publish a cutoff date in the rest of world. I think what that's telling us, if we're reading the tea leaves, is that there is also unexpected surge in the rest of world demand and usage. So beyond just China and India, which we talk about all the time, investors from the rest of the world, other countries, are also, their cases are getting approved, but also their cases are progressing to visa issuance as well, worldwide. And let's take a moment to look at these numbers, courtesy of my good friend Suzanne Lizicki, who's tabulated them and made them publicly available on her blog. So in a normal year, we have about 6,800 numbers in the unreserved. This year, we have about 11,500, so a lot more due to the carryovers. But let's look, so that's a bigger number than we have normally, so it's a big number relatively, but let's look at the actual pipeline. We have 33,000 Chinese investors and family members in the queue. We have about 3,600 Indian investors in the queue and family members. We have 9,300 rest of world investors and family members in the queue, 93. So that's nearly triple the number of Indian investors and family members. So that number, and relatively speaking to the other numbers, might be surprising. So that's a relatively high number given the range of numbers we have. And so if there is a surge in the number, demand, and usage in that category, the number of visas that are available for the high demand countries, China and India, will be lessened. And that appears to be what is happening, and to such a degree that there had to be a retrogression of this severity of over 2 years. I think the potential silver lining or good news here is that as long as the rest of the world remains current, that demand, as long as the consulates are kind of, they're able to issue these visas and the applicants continue to present documentarily qualified cases, that this demand could be absorbed and the numbers issued and used to sort of deplete that big number of over 9,000 back down and make the unreserved number available to the backlog, to the Chinese and Indian investors and family members. That would kind of get us back more into an equilibrium, at least one that we're more used to. So, of course, we're all watching this very, very, very carefully. Let's talk about what's happening in the sustainment litigation. Just today, I do not have special knowledge with respect to the litigation, just what is available more publicly. We are learning that there has been a second joint status report that was filed with the court in the sustainment litigation. And so this is a continuance of the litigation. It is ongoing. And in this report, the two sides, the plaintiffs and the defendants, put forth their respective positions in this report to the court. And IIUSA, as the plaintiff, is reporting that, we want to agree on a time frame for regulations to implement the RIA. When are we going to do it? Recall, and please refer to our prior webcast on this, that IIUSA's position is, let's do this quickly, asking for expedited rulemaking, and the service responding as defendant saying, we can't agree to any expedited rulemaking. This is, we've got a new administration. We've got to give the new administration time to analyze and understand the history of this and so forth. So we can't agree to that. And so in this second report, the joint status report, IIUSA is again saying, at least let's get a time frame on the books on this. And the service again pushing back and saying we can't agree to any specific time frame. And it has some interesting language used in articulating its position. It says that to agree to some specific time frame would be operationally impractical. Just can't do that. It's not how it works. And that doing so might be impermissibly, I'm quoting, impermissibly retroactive to the extent that it would require investors to demonstrate eligibility when filing to an unknown future standard. So it can't say we can't do anything right now because we would then be asking investors to look ahead to a future standard that's not yet been published. And you can't do that consistently with the principle that applicants for benefits have to establish eligibility at the time of filing. So there's something to further unpack there. It's kind of a nuanced idea there that I think we need to look at more closely. The service also says, interestingly, that the regulations that are on the books right now are pre-RIA. They do not reflect post-RIA law. And so they do not apply to post-RIA cases, which I think is a very interesting notion. It's one thing if we're limiting that idea to regulations that are directly germane to sustainment. But what about all of the regulations at 204.6 and 216.6? Can it be read to mean none of those regulations are within the RIA? I mean, so I think there's a big question there. It also says the service's position also interestingly notes, we can't go where the plaintiff wants us to go because we would be exposing ourselves to litigation. And it cites as a support for that proposition that the stakeholders in the private sector are not uniformly aligned with the plaintiff's position. And it notes an amicus brief from AIIA, for example. And we certainly witnessed that in action while in China. That is what we have to report for the moment. And happy to take a few questions. We do have a large live audience and about 50 folks joining our pop-up webcast today. So we can kind of like have a little conversation about this, or, you know, as ever, feel free to lob in some questions to contact@carolynleepllc.com. And we take ideas for future webcasts and questions about ones that we have had already as well. Some questions, some ongoing questions about the gold card. It's one of the things that's most interesting for me is that we get questions nearly every day from somebody as if this were an actual live program. Like, what are the requirements? A reporter asked, you know, do you have any clients who have applied for the gold card yet? So this is, as far as we know, again, there might be some sales happening that we're unaware of, but there's nothing that is available that's been publicly disseminated. There's not a form or a website portal or publication or announcement written that allows any applications to the public for this yet. Unreserved category being retrogressed. Does that give you a sense of retrogression timing for set aside, specifically high unemployment area set aside? Have you heard of any reliable analysis on this? I refer you to, hello. I refer you to a really fantastic end of year December webcast that we had with Suzanne and a couple of other, you know, very well-informed guests on this very topic, where we kind of unpacked and like we essentially ran through our numbers crunching analysis. And at the end of it, you'll hear that, you know, Suzanne and Dilip come down around, I think maybe also Lee, in terms of the high unemployment area backlog. If you're talking about like how long an approximate wait might be for an investor applying today, I'm assuming that might be the question, is you know, their estimate was like at 7 or 8 years. Mine had been a little longer because I just tend to be more conservative. Does not mean more accurate at all. And it turns entirely on the multiplier that we're using. So if you use a smaller multiplier for the number of petitions that were reported according to the FOIA output, you're going to get fewer people, fewer applicants. And so you zhuzh that through the set number of visas we have, and you're going to get a year number or a figure for an approximate wait time. I use a higher multiplier, relatively speaking. I use 2.7 because I'm figuring, you know, there's the main petitioner, and then there's the spouse, and then, you know, a little bit over half a child. So just, you know, as a rough estimate, because there are a lot of F1 single students. Of course, as we progress there, we see them also getting married, and eventually we're going to see them having children as well. So, and then my wonderful colleagues were using a smaller multiplier. They were using 2. So that's where the difference can come in. But you can key it as anywhere between 7 to 10, 11 year range. And it's so dynamic, right? So, this is for data as of September 2024. And there obviously have been petitions filed in the last 2 quarters, since that data reported out the numbers. So I'm probably closer to being right at this point, but very dynamic, all estimates, and we're going to use different multipliers. What else? Ooh. All right, while waiting. Oh. Scope of lots of great questions. Filing date. There's a question, scope of filing date to be revised for unreserved category. Yeah, so the question, as I understand it, is, so are we going to see further movement in the unreserved category? Lots of questions on this, right? So when is it going to advance again? Are we going to come back to 2016 and 2022? And if so, when? And conversely, can we also backslide and get earlier priority dates? I don't think yes, and either is possible, because as we see, this is incredibly unpredictable and very dynamic. And it, depends on things like resources and, and pace of things and how quickly petitions are being adjudicated and things like that, things that we have no control over or visibility into. I don't think that we will see a further retrogression because these dates are quite early. And my sense is that the visa office picked dates that were safe as being more, as like being retrogression proof. I'm not, these are my words. These do not appear anywhere else. But 2014 and 2019, these are very early dates. And so you can imagine that there are very few investors with priority dates, that are this early left in our system, which would be the way that I would do it too. Because if you're trying to meet, this demand that you've got to process, because we don't have a cutoff in unreserved in rest of world right now, then you've got to kind of cut off the demand in the high demand countries, so you can continue to meet the demand in the rest of world. So I would be very surprised if we see a further retrogression for China and India-born investors. So, and then the question of when would we expect to get back to the marks where we were? Maybe not until the start of the next fiscal year, but I am just guessing. All right. I didn't want to go beyond half an hour today, so that's where we'll stop for today. And this will be posted soon. Thank you so much, and we'll see you in April. What's going to happen between now and then? We'll talk about it then. Be well.